Assalamualaikum and a very good day to Madam Shahila and my fellow classmates. My name is Nursha Fitri and I'm from Group 3. Our group will be presenting a topic of membership and right of members. Our group consists of Ahmad Aziman, Amirah Nabila, Tamila Rasi Ganisan, Intan Kamaliana, and finally me myself, Nursha Fitri. The content of these presentations are the definition of membership, the registration of members, record of depositors, share certificates, duties of members, right of members, and liability of members. This topic will be explained in more details by our members.
Good morning, ladies and gentlemen. To introduce myself, my name is Tamila Ganison and my matching number is 422-300-2421. In this presentation, I will discuss the introductions of membership, including who is a corporation's member and also who cannot be a member. The Companies Act of 1965 is a Malaysian law pertaining to corporations. On 15 August 2007, Companies Act 1965 consists of 12 parts, which is containing 374 sections and also 10 appendix, including 36 amendments. Section 14 of the Companies Act of 1965, as amended in 1973, pertains to the foundations of a company. Section 4, Clause 1, defines that subject to this Act, any two or more persons united for any lawful purpose may form a corporation by subscribing their name to a memorandum and meeting the registration requirement. The new Act was approved by the Parliament in 2016 and published in September 15, 2016. However, the new Act, which is the 2016 Companies Act, only went into effective on January 31, 2017. The new Act was introduced to substitute for the Companies Act 1965, the old Act, which had been in effect for decades since its initial publication. Section 9, Clause B of the Companies Act 2016, as amended, stipulate that a company shall have one or more members. These provisions permits the incorporation of single-member company. Additionally, a company can be classified as either a private or public company. Section 2, Clause 1 of the Companies Act 2016 define a private company as having a minimum of 20 members in exempt private companies, whereas public company is defined as having an unlimited numbers of members. There is a maximum numbers of members for a public company, but Section 9, Clause B requires that there's at least minimum one member. What is a membership? A member is a company proprietor whose name appears on the company's registers of member. The members delegate certain powers to the company's director in order for them to manage the business on their behalf. What is shareholder? A shareholder is a buyer and proprietor of the shares in a company with a share capital. Numerous companies limited by guarantee lack of a share capital. Therefore, their members are not shareholders. So, what is the differentiate shareholders from members? A shareholder is the owners of a company's share, whereas a member is an individual whose identity is listed in the register of member maintained by the company. Section 2, Clause 1, Clause A of the Companies Act 2016 defines member as, in the case of company limited by shares, a person whose identity is recorded in the register of members as the current holder of one or more share in the company. In the case of company limited by guarantee, Section 2, Clause 1, Clause B of the Company Act 2016 define the terms of member as the person whose name is listed in the registers of member. For this part, there are two relevant case study was found. First, Rajul Khairul Zaman Shah bin Raja Azuddin and Oz bin Zaman Indah Sdn Bhd 1979. In this case, it was held that mere allotments of shares does not create the status of membership. Hence, membership is not based on owning of shares. The second case study is Julian Suresh Chandia v. Axis IP Sdn Bhd and Oz 2013. In this case, the court affirmed that mere allotment of shares does not create the status of membership. However, in the instance case, the allotments of shares was never effected, and thus the principle is not applicable in the instant case. Next, in court cases involving corporation, shareholders are not responsible for the company's debt but the corporation as a legal person is obligated to repay those debts or be prosecuted for non-repayment of debts. The applications for incorporations under this section must be included a statement containing the following information as required by the subsection 14 clause 3 clause E of this act: the name, identification, nationality, and also ordinary place of residence of every individual who is to become a member of the company, as well as the corporate name, place of incorporation, registration number, and also registered office of any corporate member. Okay, Section 3 of the Companies Act 2016 states that a limited liability partnership is a separate legal entity from its participant and a body corporate formed and incorporated under the Act. A limited liability partnership is required to have a perpetual existence. Any changes in the participant of a limited liability partnership shall not affect the partnership existence, rights, or liabilities. The register of members is one of the most essential statutory registries that must be maintained by every business. It is a record of the company's owners and their who stands to profit from its activities. Therefore, it is essential to maintain its accuracy and also currency. Okay, there are three sections. First, Section 50 Clause 1 defines every company is required to maintain a register of its members, which includes of their list of their personal information. Second, Section 50 Clause 3 says the register of members is proof that the thing is that has been registered is true. And Section 101 Clause 1 refers to the shareholders register, provides prima facie evidence as legal title of a share. In the case Min Yuan Holdings Sdn Berhad v Kong Ming Bank Berhad and Anor 1990, where the term shareholder is often loosely used as a synonym for member, the court held that a member need not be a shareholder where the company does not have a share capital, nor is a person who owns share in a company necessarily a member. For instance, it is possible to purchase shares on the stock exchange without being registered as a holder of the shares in the company's register of members. Thus, a person may be a shareholder without being a member. Who cannot be a member? Section 123 Clause 1 of the Companies Act 2016 prohibited a company to give financial assistance, regardless directly or indirectly, to any persons or its shareholder to acquire its own shares or shares of its holding company. Exemption is only given for public listed companies. Section 127 Clause 1 of the Companies Act 2016 refers that a company with shares quoted on a stock exchange is allowed to purchase its own share if its constitution authorizes. For its meanwhile, treasury share was declassified under two sections, which are Section 127 Clause 5 of the Company Act 2016. Shares that can be purchased by the company under these sections are only treasury share. And Section 127 Clause 8 of the Companies Act 2016 says that treasury shareholders cannot attend or vote at meetings, and other rights related to the shares are suspended. Which company is not permitted to possess holdings company shares? Yes, it's definitely subsidiaries companies should not possess equity in their parents' companies. According to the Section 22 Clause 1 of the Companies Act 2016, a parent company cannot be a member of its holding company, therefore the transfer of shares is invalid, or subsidiary cannot be added to the holding members list. Next, subsidiary was already a member in accordance with Section 22 Clause 4 of the Companies Act 2016, which stated that a subsidiary may remain within a holding company. If it already owns shares in the holding company, when it's become a subsidiary, it will retain those shares. The subsidiary already a member. What should be done? In these cases, Section 22 Clause 5 Clause A of the Companies Act 2016 stated that a subsidiary company does not have any voting rights at a meeting of the holding company or any class of holding company members. Meanwhile, Section 22 Clause 5 Clause B of the Company Act 2016 stated the subsidiary must sell all of its holding company shares within 12 months, which is 1 year, unless the register grants as an extension. And here is the reference chart regarding of Section 22 Clause 1 and also Section 22 Clause 4.
Assalamualaikum. My name is Nur Fitri and I will present about on how to become a member. There are 4 ways in order to become a member in a company. The first is upon the incorporation of the company. A person shall become a member of the company upon the incorporation of the company. If he is named as a member in the application for incorporation of the company. Next is through allotment of shares. This is when the company is issuing new shares and offers new shares to a particular person. If that person accepts, the company will allot shares today, and their name will be registered as member. Next is purchase and transfer of shares. A person may purchase the company shares from an allotee of the shares or any person holding the shares. They will become a member when their name is registered. And lastly, transmission of shares. This is when an existing member pass away. His share will be transmitted to his legal representative. In this situation, the legal representative name will be registered as a member.
Hi, my name is Nur Amira Nabila binti Amir. Okay, in my part, I would like to present about share certificates. Section 97 Company Act 2016 provides that it is no longer necessary for a company to issue a share certificate to a shareholder unless the company's constitution requires it or the shareholders apply to the company for a warrant to be issued to them. Okay. Furthermore, within 60 days from application, a company needs a share certificate to the shareholder.
Hi, my name is Intan Kamayana. So my part is duty of member. An important of duty of members is to pay the money they are liable to pay by virtue of their memberships. So if company is being wound up, each member has to contribute to the company's debt based on their liability limits. And it is also essential that members take part in supervising the performance of the company and its director to protect their financial and other interests. Okay, for liability limits, they have three, which is company limited by share, company limited by guarantee, and unlimited company. So for the company limited by share, members are only committed to pay the price of the share allotted to them. So basically, a company limited by share is a legal entity, is separate and distinct from its member. It is owned by the member who hold share in the company. So it is managed by its director in line with the provisions of Company Act 2006 and companies governing constitutional document. Okay, so next, company limited by guarantee. Members are liable to contribute a set of amount agreed between the members and the company. So as a members of a company limited by guarantee, the member collectively control the company, but they do not own it. The member does not own any share in the company, so they cannot buy or sell share for profit. When the company makes a profit, it is not prohibited from distributing the profit, but the company will usually have tight restrictions and usually about how profit are used. Okay, even when a company went up, after paying off creditors or surplus, profit may still be prohibited from going towards the salaries or payment to the director. Okay, so last is unlimited company, which is member are liable to pay all of it that if it is wound up. Okay, that's all. Thank you.
Hi, my name is Ahmad Aziman and you can call me Jiman, and I will be explaining the part of the right of members and as well as liability held by the members. The first one, the right of members. As a registered member of the company, a member is entitled to enjoy some of the rights provided by a Company Act 2016. The first right is a right to cast a vote. The second one is a right to receive notice of members meeting. The third one, a right to question any decision made or recommend or suggest recommendation. The next one is entitled to receive dividend declared by the company. As well, have a right to appoint a proxy to attend their meeting. Members also have a right to restrain the company if there is any company affair, or taking legal action against another director, have a right to defend or against in the company names, and entitled to make petition to winding up the company. Members have another two special right, which is a right for management review and right for in default situation. The first right for management review under a section 195 of Company Act 2016 stimulate that members have a right for management review. Members have a right to question, discuss, or suggest a recommendation that may or may not affect company decision making. Each recommendation to the board of member must affect the management decision making and only must be in the best interest of the company. The second special right is right in default situation. Apply in the event where company or director disobey the Company Act 2016 and refuse to correct their action. Member of the board have right to ask or demand High Court to order the company to correct their action to the default action or to the best interest of the members. As well, to inform the registrar if the annual general meeting is being held overdue. There are two methods to apply in the right of in default situation. The first one is company investigation and the second one in the case of operation. First one, company investigation. A member can ask or demand the High Court to appoint a private investor to investigate or report any company affair. However, only the High Court could decide if the investigation is necessary. If the investigation is ordered, member must bear the cost or provide a fund for the investigation. The second one, case of operation, occur when the director making decision against the interests of its members. Members have a right to demand the court to order the company to correct their costs. There is one court cases in 2021. The court cases is named Ika Nuda Berhad vs Nur Hayati binti Tukiman. The cases was begin on May 2016. One of Ika Nuda Berhad members, Nur Hayati binti Tukiman, issued a notice in request for a removal of all current director and secretary and to appoint a new director and secretary. The notice was issued to the section 331 of Company Act 2016, which allowed the members of the company to hold the AGM. However, when the section 331 is applied, the section 312 of Company Act 2016 come to the play where the director receive the notice and the AGM must be issued within 14 days from the request date and the AGM must be held within 28 days. Fail to do so brought the self-help remedy under the section 312 of the Company Act 2016, where Nur Hayati can issue a notice date and time of the AGM to be held within 3 months from the request date. On 2 June, Ika Nuda Berhad filed a legal action to essentially seek declaration to invalidate the request notice and to invalidate the holding of AGM on the end of June is invalid and void. For the court decision, the court reject Ika Nuda Berhad vs Nur Hayati argument as the request notice was brought by a single members of the company and notice itself didn't attach any written consent or purpose of a new director. The intended removal of all company director will breach the Company Act 2016, where public listed company must have a minimum of 2 remaining directors. The defendant request notice was still valid despite the defendant having a fixed date and venue for the general meeting. The directors still at liberty to fix any date and venue they deem fixed for AGM. In any case, the director did not give any reason on the non-suitability of the date or venue, or was there any evidence of prejudice simply because of the request notice fixed a date and venue. The defendant request notice was valid even with the removal of all director. There was nothing to prevent the resolution on the appointment of a 3 new director to be voted upon first before the resolution to remove all existing directors. The removal and appointment need not follow the sequence set out in the general meeting notice. That is the case of Ika Nuda Berhad vs Nur Hayati binti Tukiman. Now, up for last part, the liability held by the members. So, as taught by Madam Shah, a company is a separate legal entity between its members and the company itself. So, only company is liable to its debt as the company and member is separate legal entity. Member is liable for company debts in the event of corporation winding up, but depends of the type of company. Unlimited company members is liable and need to bear the company debts, while for the limited company, in accordance with the section 192 of Company Act 2016, the liability of members in the event of winding up is only limited to A, share, the amount of unpaid share, only the amount of unpaid share, and not exceed the full pay amount of share. B, guarantee, the amount director undertake or willing to contribute in the event of winding up. For example, if Intan Kamaliana as a members willing to contribute 200 ringgit 200 ringgit in the event of winding up, in the event of winding up, company only able to claim 200 ringgit from Intan Kamaliana. So that's all for liabilities of members, and that's all from my part, and that's all from us. So if there is any question, please don't ask me, ask Intan or not anyone else. Okay, bye.
The overall topic that we have done present just now, I want to conclude it. Any organization that allow people or entity to subscribe and frequently require them to pay a membership fees or subscriptions is a membership organization. Membership groups often have a specific function, which include bringing people together around a specific interests, activities, industry, region, or professions. This just might be to promote or enable communication and teamwork, but it also frequently entails advancing the original goals. The majority of membership organizations are non-profit, but there are also numerous that are managed for profit, and some bigger non-profit membership organizations have commercial subsidiaries.